We have such a distinguished panel here tonight. I'll move along and just give highlights of in introducing them and give you a perspective of what they will be talking about. We basically have experts who will be giving us their perspective on historical, legal, political, and policy perspectives relating to this case. That is, as the students mentioned, have been going on for over a decade now. We have with us the Chancellor of the Southern University Law Center, Professor John Pierre. Chancellor Pierre has been on the faculty at the Southern University Law Center since 1990 and has been Chancellor since 2016. Had a distinguished career in working and molding lawyers as leaders. He will be talking about the historical perspectives of de jure practices here in the state of Maryland. Following Chancellor Pierre is Attorney Pace McConkey. Attorney McConkey is a civil rights lawyer and also a professor at Morgan State University. And he is the founder and director of the Robert Bell Civil Rights in Education, Robert Bell Center for Civil Rights in Education at Morgan State University. And he'll be talking of specifics relating to the lawsuit. We are also pleased to be joined by two members of the Maryland General Assembly. First, we will hear from Delegate Daryl Barnes. Delegate Barnes represents the District 25, which is Prince George's County, in the Maryland General Assembly. He's been an outstanding leader there and a great deal of community service, among which he was the founder of an organization called Men Aiming Higher. He may want to talk about that a bit, how that relates to the importance of this legislation. And then following that, we have State Senator Charles Sydnor. Senator Sydnor represents District 44, which is Baltimore County. He has been a state senator since 2020. Prior to that, he's a member of the House of Delegates representing that same district. And we'll note that Senator Sydnor is a graduate of University of Maryland Law School. And then our final speaker is Professor Isami Miller from Bowie State University. Professor Miller has really a long, distinguished history in writing in legal history for a number of different journals, including the Journal of Negro History, the Black Collegian, many others. And he will offer his recommendations on a solution to this very difficult issue. So let us start then with Chancellor Pierre. We appreciate it, and we hope Louisiana has warmer weather than we have, but I know that you'll offer us an important perspective. Now, unfortunately, ladies and gentlemen, we're going to have to have our speakers give us basically their highlights. They could all speak for a long time on this issue, but in order to make sure we get people involved in the question and answer, we'll ask them to just focus on the highlights of their presentation. Again, Chancellor, thank you.
Thank you, President Schmoe. First of all, I'm honored to be able to present this evening, and I want to thank the students from University of Baltimore Law School for this invitation. And being here this evening is certainly the highlight of my month during Black History Month. So I thank you. So I want to bring you a historical perspective. And again, it's going to be a high level, but it's important that we talk about the history of Maryland's segregation in higher education. So we think about the United States history and the separate but equal doctrine, and the fact that we had slavery, we had the 14th Amendments, the 13th, 14th, and 15th Amendments, the Emancipation Proclamation. So let's see how Maryland fits into all of this, this whole structure in American history. So Maryland, basically, history documents the existence of segregation in education beginning as early as 1807, 1825, and 1866. When we think about public higher education in Maryland, Maryland first instituted a system of publicly funded higher education in 1807. Maryland was a slave-holding state. And of course, Maryland did not join the Confederacy during the Civil War. So technically, slavery ended in Maryland in 1864. But Maryland was not part of the Confederacy. The idea of free public education, what we would know now as K through 12 education, was begun as early as 1825. And the key to this whole deal is that when Maryland establishes colleges and universities, they establish them by race. So in 1866, 1 year after the end of the Civil War, 2 years after the end of slavery in Maryland, and 2 years prior to the 14th Amendment, the superintendent of education in Maryland declares and recommends that the state should provide separate publicly funded education for African-American children, separate from white children. So here is basically how they create the white-only higher education institutions. University of Maryland at Baltimore, actually, that's 1807. What we now know as University of Maryland College Park was begun as University of Maryland Agricultural School in 1865 to take advantage of the newly minted Morrill Act, Land Grant Act of 1862. Towson State is created, or Towson University is created in 1866. Frostburg State University is created in 1898, and Salisbury State University is created in 1922, all as white-only institutions. What is truly amazing about the Maryland higher education experience for African Americans is that African Americans, the newly freed slaves, took control of their educational destiny, because what we now know as the 4 publicly funded HBCUs in Maryland all began as private institutions. That is truly amazing, no matter how you think about it, that the former slaves in Maryland had the foresight to create the institutions themselves. And many of them served as what we call normal schools, educating from what we would consider now first grade all the way up to college. So it's really important to give you that history. So in 1908, the state of Maryland assumes control of the Baltimore Normal School, which was an all-Black teacher school, which is now Bowie State University. In addition to that, Prince Anne's Academy was a private school. It was taken over by the state of Maryland in 1919 and designated as a land grant. We also have Morgan College, which now is Morgan State University. It becomes a publicly funded university. And of course, Coppins Teacher College, now Coppins State University. It was originally formed by the Baltimore City School Board in 1900 to train Black school teachers. It was operated as part of the colored high school in Baltimore until 1909, and it was renamed in honor of Frances Jackson Coppin, a former slave who became the first African-American woman to earn a college degree in the United States. So basically in 1938, Coppin becomes a 4-year institution of higher education offering bachelor's degrees in education. Now, the role of Maryland in desegregating higher education and public education is no small role. Louisiana, where I am now, is famous for Plessy versus Ferguson, the separate but equal doctrine. But Maryland is one of the places where there's a challenge to the separate but equal doctrine within 20 years of that decision. It began with the Black teachers who formed a union who basically had an idea of equalizing teacher pay. And it begins with a series of cases litigated by Thurgood Marshall in the 30s, leading to a case most of you know now as Murray versus Pearson, which leads to the admission of the first Black to the University of Maryland Law School, okay? And then leading to another series of cases where Thurgood Marshall and Charles Hamilton Houston litigated higher education cases to essentially collaterally attack the Plessy versus Ferguson case. They never directly began to really attack Plessy versus Ferguson until the 1950s. Interestingly enough, the state of Maryland realized it had a problem with educating African Americans. They commissioned two studies in 1937 and 1947 to show the inequality in higher education with respect to that. And there are a number of cases where even though on a national level, higher education is recognizing that African Americans have a right to attend previously all-white institutions, Maryland is slow to admit African Americans to institutions in Maryland, despite the fact that in 1936, Pearson versus Murray, or Murray versus Pearson starts the whole process. So we learned that later there's a lady named Esther McCready who has to sue the state of Maryland to get admitted into nursing school because Maryland had a program that allowed African-American students to go to Fisk, to Meharry Medical School if they wanted to be in nursing. We see other people like Perrin Mitchell, who sues the University of Maryland in College Park to be admitted into its graduate program in sociology. And we also see people like Hiram Whittle, another African-American resident of Baltimore, who wants to study electrical engineering at the College Park campus. He gets admitted later in the 50s, as well as the University of Maryland Medical School admits Donald Stewart and Roderick Charles, both residents of Maryland, after lawsuits are filed.
Chancellor, I may have to cut you off in a minute.
Yeah,
because you're bumping up against the lawsuit now.
I got you. But the point is this: Thurgood Marshall created the pathway for higher education desegregation and public school desegregation out of Maryland. So Maryland has a very proud history for leading this effort.
Thank you. Well, let me go then, because that is a good segue to Professor McConkey with respect to the current lawsuit.
Thank you, President Smoke and members of the law school and all who are participating in this panel. At the Robert M. Bell Center for Civil Rights Education, we primarily focus on any continuing policy or practice in education that would foster discrimination on the basis of race or perpetuate the inequities of segregation by race. And then through research, teaching, training, and advocacy, we seek the elimination of those discriminatory policies and practices. And really that's the sum and substance of what this litigation is all about. I'm very grateful that the Chancellor has laid a foundation so that we can have this discussion about the lawsuit in the context of long-standing Jim Crow segregation in Maryland. And this lawsuit really links policies and practices that propped up that Jim Crow segregation. It links and is traceable to the foundational racism, the foundational white supremacy and white privilege of the era of slavery, the era of lynching, the era of Jim Crow segregation, to the contemporary policies and practices that remain in place right now, and which either by intent and designated purpose or by discriminatory impact or effect violate the constitutional and civil rights of African American students and have for decades removed them from mainstream opportunities for meaningful educational excellence and advancement otherwise available to their white counterparts. The lawsuit was not filed by HBCUs in Maryland. HBCUs are part of Maryland. The lawsuit was filed by a coalition of students, faculty, alumni, and supporters of the four historically Black institutions. And primarily, its claim was to assert that the state of Maryland had not undone the de jure segregation that resulted in exactly what the chancellor has described. And after considerable litigation in 2013, U.S. District Court Judge Catherine C. Blank ruled that the state of Maryland continues to maintain and perpetuate a separate and unequal system of higher education that is segregated by race and which discriminates against the rights of students who attend the state's four historically Black institutions. And it found liability against the state primarily based upon the policies and practices by which the state of Maryland would approve and assign academic programs, the lifeblood of higher education, the lifeblood of any campus, that which brings students to its campuses, that is by which degrees are granted and privileges extended and careers ultimately made. The court found that the way the state approved and assigned academic programs and then unnecessarily duplicated the academic programs at the HBIs at geographically proximate, traditionally white institutions was unconstitutional, and a remedy was required. There were other claims that were brought by the coalition addressing the manner in which missions were assigned to the separate campuses. Also, there were challenges to the financing and budgetary practices, which resulted in dramatic underfunding of the HBCUs. But the court did not find liability on those two claims because they found that the way the state assigns missions now, the way the state funds institutions of higher education now, was not directly traceable to the de jure system. But the way the state approved academic programs and unnecessarily duplicated programs at the historically Black institution was directly traceable to the de jure era. And here are just some examples of findings of the court. Key findings included unnecessary program duplication in Maryland is widespread, is traceable to the de jure segregation era, and harms Maryland's HBIs. As such, Maryland has a dual structure of higher education that is segregated by race. Given the large disparity in the number of unique high demand programs, which at the time of trial was 122 unique high demand programs at the traditionally white institutions, as compared to 11 at the HBIs. And 4 years later, at the time of a remedial trial, that had grown to 170 to 11. The court said there's nothing that distinguishes the HBIs programmatically. It found that Maryland's dual structure and concomitant harm to the HBIs is a direct result of the continuing failure of the state to address the de jure era policy of duplicating programs to maintain a dual segregated system. Interestingly, the court found that in lieu of investing in these HBIs, to create them as diverse institutions, It heavily invested in Towson University, created and invested in UMBC. It brought the private University of Baltimore into the Maryland system of public education, and then expanded the University of Baltimore to include freshmen and sophomores. It continued to allow unnecessary program duplication despite promising to discontinue this practice in a 2000 partnership agreement with the US Department of Education Office for Civil Rights. And it allowed the duplication of Morgan's MBA program over the objection of OCR, and despite the advice of the Attorney General's office. It also cited that the Maryland Higher Education Commission had not effectively addressed unnecessary program duplication, and that MHEC's safeguards were really only forward-facing and did not address the substantial duplication that existed since essentially the beginning of Maryland's system of higher education system.
So,
President?
I just note that that was in 2013, and there was a long-standing attempt to resolve those issues. We'll come back to that, but I know that some attempts to resolve this have gone into the legislative branch.
Let me state in transition, President, if I could,
yes,
that what the court expects out of a remedy, and then we'll see how the legislation might be able to do that. The court just laid out a framework for the remedy. And that framework, according to the court, would require an injunction against the practice of unnecessary duplication of programs. 2, it would require an enhancement of existing academic programs at the HBIs and an influx of new high demand programs that would remain unique to the HBIs, in other words, not duplicated at other institutions. The court would consider the creation of academic niches or areas of excellence at each of the 4 HBIs so that they could be identifiable by academic programs and missions. And then there were other aspects like transfer of programs, mergers, and so forth, which the court ultimately did not entertain. But because the constitutional violation was a programmatic violation, it required a programmatic remedy to bring the HBIs into a position where they were comparable to and competitive with the other institutions.
great.
And those efforts by the parties to resolve and agree on a remedy were not successful. The case is now in the United States Court of Appeals for the Fourth Circuit, pending a decision, but the court is certainly aware of the efforts by the state and the coalition to resolve this case and settle by virtue of legislation where these 2 distinguished legislators now come in.
And they've been outstanding leaders on this. And I believe that Delegate Barnes is going to start us off with very important legislation in the last session and now in the current session. So I'll turn it to you, Delegate Barnes.
Well, thank you, President Smoke, for the opportunity. But I've learned during my time here that I never speak before the senator. So I'm gonna definitely let the senator speak before me. But I think Pace did an outstanding job in laying out the case itself and where we are. But I think Senator Sydnor will be able to put it more in context to where we are from a legislation standpoint and the movements that have been made to date on this case. And then I can then summarize from his layout on how we got to this point of getting legislation introduced from this being a now 14-year-old lawsuit to the point where we now are finally starting to get some movement. So President Smoke, if you don't mind, I'd like to pass it on to Senator Sydnor.
I appreciate that. I just want you to know, I understand generally the way in which these things work. I happen to get a note from your staff just giving me the opposite. So that's.
I know I'm on the timeline, but I want to follow protocol.
Good, Senator Sydnor.
And good evening. Thank you to the UB family and UB's boss for having me this evening to talk about our legislation. But before I go there, I just wanted to make just a couple minor corrections. As a proud alumni of the University of Maryland School of Law, I just wanted to make note that Donald Gaines Murray was actually not our first Black alumni of the law school, but Harry Scythe Cummings graduated from the school back in 1889. And there may have been one or two other Black students who attended the University of Maryland School of Law. However, the dean and the school made a decision that they no longer wanted Black students attending the school. And by the 1900s or the 20th century, there were no longer Black students who attended the University of Maryland School of Law. Now, with that said, President Delegate Barnes and I, we both came into the General Assembly together and were sworn in 2015. We've both been active in the Black Caucus. He's currently the Black Caucus president. I'm no longer on the executive board, but in the time where I was on the executive board, and since I've been a member of the Legislative Black Caucus, getting this case settled had been one of the priorities of the Legislative Black Caucus because of, actually, I was about to say because of my interest. Somehow I ended up being the chair or sub-chair within the Black Caucus, whose efforts were to be honed towards trying to figure out a way to get this matter done. So as Mr. McConkey laid out, there was a framework that was put forth. I believe he and I and President Richardson and members of the coalition that had put this lawsuit forth came together and they really educated me on what the situation was. So one of our first pieces of legislation was actually introduced back in 2018, where we attempted to create a special advisor whose job was to be appointed to develop this remedial plan that Judge Blake had noted in some of her findings. That bill went absolutely nowhere. In fact, I remember commiserating with some of my colleagues that, in terms of public support and everything, it just wasn't there. Institutionally, the support wasn't there within the houses, and the bill, it died. Last year, with the changing of the guard, we got ourselves a new speaker, a new president, and I think the bill just found some new life with new leadership. So last year, we introduced a different bill. Rather than trying to deal with a special advisor, the speaker, Adrian Jones, and I introduced legislation that attempted to put a number on a settlement. And that number, after having conversations with the coalition, was $577 million. And so then we had to kind of work to figure out how to do it. We structured it so that the money would be allocated over the course of a 10-year term amongst the 4 schools. In working with President Barnes, we tried to organize, working with a lot of grassroots organizations, which was we I think did much better than we did when I first introduced this bill. We ended up having a rally which Delegate Barnes, he had suggested and tasked me with doing in about 3 or 4 weeks. So I will tell you, as I told him, I was not someone who knew how to put together rallies. So it ended up being a real stressful time for me. So I was pleasantly surprised that we had the number of people coming from the 4 institutions showing their support, the number of legislators who came out to show their support. And it really gave us a lot of momentum going into the session. And it became a priority of both on the House side, and we got a new leader on the Senate, and Senator Bill Ferguson. Became a priority for them, and ultimately the bill was passed. Unfortunately, the governor, he vetoed the bill, and this is a bill where I believe there are only 2 legislators that had voted against this bill, and those 2 are in the House. It came out of the Senate unanimously. Nevertheless, he vetoed the bill. So we had it was a timeline within that bill that the coalition would have had to have settled the lawsuit and had a settlement agreement with the state of Maryland by within the first 2 weeks of December of 2020. With the veto, we were hoping that we may have been able to have some sort of a special session. When it became abundantly clear that there was not going to be a special session within the General Assembly, while many were calling for a veto override, the fact of the matter is that overriding a bill that had that type of time frame in it, it didn't make any sense. So leadership, again, in the House and the Senate, they made it HB 1, Senate Bill 1. Was reintroduced. We had early hearings. While I'm not exactly certain where everything is over in the House, and maybe Delegate Barnes can touch on that, I do know that it passed unanimously out of committee again, and it was on the Senate floor just 2 days ago, passed second reader, and it's my understanding, I believe it will be on third reader tomorrow. So, I mean, this is very, very timely. And we were about to see, I think, history happen again.
Thank you very much, Senator.
Thank you very much, Senator. Let me just say that Senator Sydnor and I ride on the shoulders of you gentlemen that's on this call. I think Chancellor Pierre broke it down eloquently, the history of our 4 HBCUs here in the state of Maryland. I believe that Mr. McConty broke down the lawsuit in a way that folks can truly understand. President Smoke, you have been an institutional individual here in our state for quite some time. And I think this lawsuit has been going on now for 14 years. 14 years. This is totally unacceptable. That we are still in the year 2020 fighting for and dealing with systemic racism in the state of Maryland. If it was not for folks like Senator Sydnor, who came in 2014, 2015, and rolled up his sleeves and said that I want to do my part, I don't know where we would be right now. And we have to understand that, yes, there have been other delegates and other senators who have advocated to settle this lawsuit 13 years ago. But it's gotten to now where Senator Sydnor has come in, and we are finally starting to get some movement. And I am thrilled by that. And I think that from a historical standpoint, I feel real proud to the fact that the rally that was put together, the number of young people that came out from every HBCU in the state of Maryland, and some from around the country. The Divine Nine also got involved. Roland Martin got involved. There were other media individuals that got involved that said, enough is enough, and it's high time that the state of Maryland follows suit. if you look at what Mississippi settled their lawsuit with, and where the state of Maryland is right now, the settlement that we're offering is far less than what the courts have already said we should be receiving. So I think that we're at a point right now where we are coming to an end, but it's still not what we deserve. But I am excited that through legislation, that we are now to a point where the Speaker of the House, the Senate President, and the members of the Legislative Black Caucus, and all the members in the Maryland General Assembly are now saying that we must do our part, and we must give our 4 HBCUs here in the state of Maryland the necessary money they need to settle this lawsuit, to help with the duplication of services, to help with recruiting measures, to put them at a level playing field with our white institutions here in the state of Maryland. That could not have happened for us to even be at this point if it wasn't for you 4 gentlemen and the students at these institutions who have all stood up and said that we must do something and our voices must be heard. Our job, what Al Sharpton told me, he said, Delegate Barnes, continue to be the fighter on the inside. Use folks like me and these 4 gentlemen and the students on the outside, because we must continue an inside-outside game in order to make sure that we pass the necessary legislation that's needed. That's the only way that this is going to happen. You guys are scholars in your own right, but in order to get anything passed from a legislation standpoint, you have to have fighters like Senator Sydnor, who's willing to challenge the status quo to make sure that we're getting the right pieces of legislation in front of our presiding officers, that we are networking on both sides of the aisle, and that we are saying the right things in order to make this happen. So I am happy, I am thrilled to be here. I continue to stand up and fight every single day. You know, the Legislative Black Caucus of Maryland, we're 58 members strong. Hopefully by next week, we'll be at 59 members. Second largest Black caucus in the union outside of Georgia. It takes 71 votes to get a bill passed. We control the narrative. We control 1/3 of the caucus. So I am excited about getting this bill passed. I feel extremely confident that it will happen this time. We're going to get the bill passed in enough time that should the governor veto it, we have enough time in session to override it. We have enough time to ensure that the money goes to these 4 HBCUs. We have enough time to ensure that our students that are in the school system now will be able to at least be at the same level playing field as our white institutions here in the state of Maryland and across the country. We have enough time to ensure that programs at our 4 HBCUs are up to date. We have enough time to ensure that we can put forth new policies and procedures so that this never happens again. So I thank you guys, all of you all. I know I have not heard from Mr. Miller yet, but I know he has a compelling story as well. So if there's anything else, you know, I am here. Unfortunately, I have a hard stop at 7 p.m., but I thank you guys so much.
Thank you very much, Delegate Barnes. And yes, let's turn to Professor Miller. Dr. Miller is currently a member of the history department at Bowie State University, and Bowie is one of those 4 HBCUs that would benefit from a great settlement here. Dr. Miller?
Thank you so very much. Can you hear me clearly?
Yes, sir.
I want to thank the other panelists for laying the table out so wonderfully for me in terms of the history from the chancellor, from the other legislators and the other attorney, because you laid the foundation for me, and I think I'm going to capsulize and bring this all together from the standpoint of those of us who are in the trenches every day. I'm speaking on behalf of both the vested full-time faculty, the adjunct part-time faculty, and the many dedicated staff persons who make these institutions run day to day. Like healthcare workers, we're on the front lines to support our thousands of students and our community surrounding these institutions. For me, I'm entering my 5th decade of teaching in higher ed. I got hired in 1971. I passed everybody, I'm still there. This is my 49th year as a full-time faculty member. I would like to put a shout out for the great Samuel L. Myers, who just passed at 101, who hired me. You know, we stole him from Morgan. He came to Bowie State and made us a great institution. I owe him so much because he hired me full-time in 1972. What is our problem? Retention of competent full-time faculty and staff is the #1 problem. One short solution, and I've heard it from the legislators, we need salary equity with our peer sister institutions at all levels. We're just like sports. They take our best and brightest always and lure them away from money to the larger and better funded institutions. We need auxiliary complements that are not available at the HBCUs. By that, I mean we need better infrastructure on all levels. Amenities are always a temptation to leave, and what people seek and perceive as a better environment. Non-existent or competitive programs, especially in technology, medicine, medical allied fields, engineering, where the higher paying salaries for graduates either don't exist or underfunded at HBCUs. We're still fighting on all levels this decades-old battle. Even our senior administration, there are disparities that need to be reconciled. Some states like Pennsylvania have sought to resolve this issue somewhat and provide a model how to approach and begin to resolve these inequities. But even they are faced with enrollment crisis and program duplication, which you've heard noted here tonight. Here's the real problem for the HBCU: how to maintain and retain our historical significance as the primary deliverer of higher education to the Black community and providing the basis for our future leaders in government, industry, and the community, while at the same time not closing the door on diversity and inclusion, to which others so wrongly denied us over the years, as you've heard. We have suffered since 1865, since the Reconstruction and the Jim Crow era, and I salute and thank the legislators for their valiant fight for taking us to the next level. Thank you so very much.
Thank you, Dr. Miller. Because Delegate Barnes has to leave, let me ask you a quick question. Just your perspective on the possibility of passing of this legislation actually getting around the governor's veto this time. Do you think it'll suffer the same fate that it did last session?
Well, let me just say that I believe Senator Sydnor said it earlier, that it will be on third reader in the Senate this coming Friday, tomorrow. The bill will be heard in the House tomorrow. So the intent is to try to get it through in enough time, should the governor veto it, which I would expect that he would, that we would then have enough time to override that veto before session ends in April, which would then put this bill into law.
Great. And your perspective, Senator, do you think you're going to win this time?
You know, I think we won last time. And I think that we won when we had bipartisan unanimous support over here in the Senate this time. As I had said in an interview with the Daily Record, I don't want to count my chickens before they hatch. I mean, obviously, until I see those numbers on the board saying that we've won, I don't want to jinx anything, but I feel real good where we are.
Right.
I think in where we are is going to put a lot of pressure on the governor to do right by this bill this time.
Professor McConkey, what is your sense of if this legislation is passed and the veto is overridden, is what's in this bill sufficient to lead to a settlement? Because it's been very difficult to settle this matter over the last few years.
Yes, if this bill is passed, the coalition will represent to the court that the remedy can be implemented, at least initially, with the appropriation of $577 million over 10 years. And because it is, that money is focused on pretty much everything that Dr. Miller described. It is focused on what is necessary to bring new programs to these institutions and keep them viable. That's recruitment of faculty, keeping faculty, retention of students, financial aid to students, marketing. But more than anything, the money will be used to bring mission and programmatic identity to these HBCUs in perpetuity. And that is responsive to the plaintiff's case. It is responsive to Judge Blake's findings and conclusions and her remedial order. And it frees up the state. It frees up the state to finally do the right thing and begin implementing a remedy for longstanding segregation. So I think it's a very, very positive development that I hope all sides of the issue will accept and move forward on.
Chancellor Pierre, I was just wondering, you looked at a number of these cases around the country. Is the Mississippi case very different than what is faced here in Maryland?
It is in this context. So the Fordyce case, there were two references. The ultimate settlement in Fordyce was that a $500 million trust was created to fund Alcorn, Mississippi Valley, and Jackson, where that's a permanent trust. And they have to meet certain requirements to be able to access funding from the trust. In Maryland, what you had was a situation where the actual alums and coalition focused on something that was very, very important, which is the fact that you had duplicated programs over and over and over again designed to limit the growth of HBCUs. So for example, Towson was allowed to bring on a whole bunch of programs that probably thwarted the growth of Coppin. And in the 70s, University of Baltimore, which was a private institution, was made a public institution. There was a creation of the University of Maryland, Baltimore County. When you had an institution, Morgan, that could have done everything. And in fact, it was Dr. Richardson that fastidiously kept all kinds of records and notes to show how this was done and was able to bring actions to the Higher Education Commission to challenge the University of Maryland's duplicative attempts. And the same thing happened with respect to Bowie. In many respects, there's a role even in community colleges where Prince George's Community College has grown in many different ways that have thwarted the growth of Bowie. Yes. So same thing with Salisbury up in the Eastern Shore area. So here's the critical thing. In 2005, the state of Maryland admitted it had a dual system of education. 15 years ago, or 15 and a half years ago, they admitted that, which led to the lawsuit finally being filed in 2006, 1 year later. So there's no denial of these practices.
Great. Ms. Thomas, there are a number of questions, and I don't want to cut off my connection. Maybe you could put some of those questions to our panelists.
Yes, we actually have one guest with a hand raised, Naseem Jabari. If you have a question, you can unmute yourself. In the meantime, there's one question that asks, what are the agreements between historically Black institutions and traditionally white institutions in regards to program transfers, and specifically which programs?
I think Professor McConkey could probably address that.
consistent with the program, with the remedial proposals submitted by the plaintiffs and the remedial order of Judge Blake, there's room for the HBIs and the traditionally white institutions to agree on transfers as part of a remedial effort. But candidly, there's been a lot of resistance to that. I'm not aware of specific programs that are in the works that will result in a transfer of programs back to the HBIs. It's a possibility under the judge's remedial order, but I don't see it happening right now. And there has been great resistance to transfers as part of the moving forward. But the door is open.
I can just tell you one program that triggered, one of the programs that triggered this lawsuit was a joint MBA, Master of Business program that was approved by the state involving Towson and the University of Baltimore. And we allowed that program to end. So that particular program no longer exists. That's the only one that I'm aware of now that has, as a result of the lawsuit, a change was made.
Nasim, I think we've unmuted you so you can ask your question, but I would like to direct the rest of the questions to the chat, the Q&A function, so I can read them aloud. Doesn't look like it's working. Let's see, there's another question on behalf of the Iota Lambda Omega chapter of Alpha Kappa Alpha sorority, which asks, what is the most effective thing or things that the Divine Nine can do now and in the near future to support the settlement?
I think Delegate Barnes, you raised the Divine Nine in your comments.
Yeah, I just saw Senator Sydnor sit up on that one. He's a fraternity guy. Go ahead, Senator.
No, I was about to say, last year we met, we had a conference call with all of the leadership of the Divine Nine organizations, and they put together a letter in support of what we did last year. We certainly did not reach out again this year, but we had a number of organizations or chapters taking it upon themselves to have their own campaigns and emailing your legislators. So, I mean, I would just say continue doing that. Make certain you know who your legislator is, you know where your members live, and have them reach out to the legislators and just let them know the importance of the passage of this legislation.
Yeah, and I would just echo that everyone that's watching and those that are even on this call is to go to the Maryland General Assembly website, and you can start your own letter campaign asking all of the legislators to support House Bill 1 and Senate Bill 1. That is the HBCU bill. And that's a easy remedy because I think the more that our legislators can hear from ordinary folks on the outside, that's important to get their attention.
President, can I add something to those responses?
Certainly.
Thank you. I think one of the great lessons we learned from this case is that it stands on the 4 traditional pillars of civil rights advocacy, which are education, agitation, litigation, and legislation. We've seen that nationally. We've seen it in many other states. It's playing out perfectly in Maryland right now. And that describes a role for virtually everybody. Now, not everyone are going to be legislators like Senator Sydnor and Delegate Barnes. Not everyone are going to be litigators like the attorneys in this case. But certainly all of us, to an extent, can be educators like Professor Miller and the Chancellor or educating in our own circles and in our own spheres. And certainly, we can all be agitators in an appropriate way, whether it's by contacting legislators or the governor's office, or otherwise just speaking out. I just think this case provides an opportunity for everybody, whoever we are, whatever our circles and spheres are, to move this case to a proper settlement and conclusion.
Ms. Thomas?
All right, our next question asks, how will House Bill 259 by Delegate Ivy affect the previous legislation regarding the allocation of funds to the 4 HBCUs of Maryland?
Fortunately, I'm not familiar with Delegate Ivy's bill. Maybe Senator is.
They're total different pieces of legislation. The delegates bill is a bill that looks to, and I don't know if he uses this term or not, but to essentially emancipate the 3 of the 4 of the HBCUs from the University System of Maryland. Obviously, Morgan is already its own institution and not a part of the University System of Maryland, but that legislation and this legislation, two total different things. So I'm not certain where that stands or the type of or who's supporting. I'm not even certain whether or not the institutions support it. So I'm not certain.
Let me ask Dr. Miller, has there been any conversation about that? The legislation basically would pull the remaining 3 HBCUs out of the University System of Maryland, give them the same status that Morgan has.
Yeah, I think they'd be split right down the middle. You would have older faculty, I think, probably wanting to stay in the system, because I was in the old system when they had the Board of Trustees, and there were many benefits that we did not get when we were not in the university system. But once we entered the university system, it did change on how programs were approved and what you got and what you didn't get. And you had to fight 10 times harder to get anything approved through the Maryland Council of Higher Education. So on one hand, it was a blessing in terms of insurance and tenure and benefits to the individual, but to the institutions, it was very harmful. So I think the older faculty might wish, because of the benefit part, to stay. The younger faculty who never knew that system might be more anxious to be emancipated. But you got to remember, when you leave, you're on your own, and it does mean some kinds of things you have to do differently. I would like to respond back to the young lady from Alpha Kappa Alpha Sorority who asked what could be done. I'm a fraternity person, and I've been chair of the Panel Council. Each fraternity and sorority has a commitment in its bylaws to support federal and state legislation. They have youth meetings where they are mandated to take care of social action. So when the Panel Council on your respective campus meets, this should be a social and political action activity where they could incorporate into what they do as part, besides stepping and marching, which is okay, but there's some things that you have to do to the community that you are required to, so you can continue to exist. And I think what the young lady can do is go back to the Panel Council and do 2 things. Ask the entire organizations, all 9 of them, this is something that we need to support to continue our institutions to exist, and also to support our legislators who are fighting for this. Write those letters to the governor. Write those letters to all, even the people who disagree with you. Put it in writing. I can vote. And if you don't support this, I'm not going to vote for you. That's a very simple thing. That will get people's attention in a quick, fast, and a hurry. If you say, I'm not going to vote for you, I'm going to support your enemy, I guarantee you, you will get some response. So there's a very serious thing that these attorneys and sororities can do. And then within the organization itself, plus you're in regions. So your region could support this, just not the state of Maryland. So there's many reasons, because remember, we have students who come from Delaware, Washington, D.C., Pennsylvania. We have out-of-state students who also benefit from being in Maryland. So we got to put everybody's feet to the fire. Everybody has something at stake to lose at this. And so these Greek organizations must stand up and be accounted for. Again, not knocking stepping, but that's just one part of your job. And this is my 56th year in the fraternity, so I know what I'm talking about.
President Smoke, I have to leave, but
Yes.
thank you guys so much for the opportunity. And if there's ever any questions or anything I can do, please stay in touch.
Thank you very much, Delegate Barnes. We recognize how busy you are down there. Appreciate you giving us this time.
Yes,
And you're from my area, PG.
there you go.
Ms. Thomas?
We have another question which asks, is there an actual plan to create academic niches among the HBIs as one of the speakers mentioned?
Pace.
Well, I guess I'm the speaker who mentioned that. I appreciate the question very much. Specifically, I can identify what was proposed by the coalition as part of the remedy and entertained by the court. And that would be to create academic niches or areas of excellence at each of the 4 institutions. Specifically at UMES, those academic niches were identified as engineering and aviation sciences, agricultural and environmental sciences, pharmacy and health professions. At Bowie, they're identified as computer sciences and professional fields studies, including nursing, social work, and education. At Coppin, nursing and allied health, criminal justice, applied social and political sciences. And at Morgan, business and management, urban environment, health and sustainability, and engineering. Now, those were crafted with input from the presidents of each of the 4 HBIs and with input from the faculty, as a matter of fact, who submitted input to the coalition and directly to the court. Now, that was part of a remedial proposal, and the court's remedial order was for a special master to work with these institutions, appointed by the court to work with these institutions to identify specifically the niches, the programs, cost it all out. Under the legislation, I think Senator Sydnor can clarify if I'm wrong, but under the legislation, there would be the possibility of consultants working with the presidents, the faculty, each of these institutions to specifically identify these niches and potential programs that would be implemented with the money appropriated. So I hope that's helpful.
That's correct.
Great. Next question.
Okay, the last couple questions have already been answered partially by Senator Sydnor. They ask, did the governor ever give a justification as to why he vetoed the bill? He said he claimed it was budgetary. I don't know if anyone would like to add it on to that answer. And then the next question asks when we expect the actual vote on the bill to take place. If the governor vetoes it, do we have enough time to override the veto? Would you guys like to talk about the next legislative steps?
Sure, and Delegate Barnes touched on this a little bit. Again, so a bill, in order to be made into a law, it has to go through both houses, first, second, third readers. Because the House had a version and the Senate had a version, each bill goes through that step in both houses, first, second, third reader. And then if the bills come out not in the same posture, if anything, if even a comma is changed, it would have to go to a conference committee. And if there are things that need to be addressed, then they will be addressed there. But hopefully, these bills will come out of both houses or both chambers in the same posture. And if that's the case, then at that point, once the bills have passed both the Senate and House chambers, then they go to the governor's desk. And again, the idea is that we get this thing passed as soon as possible, so that if the governor decides to veto it again, we'll still be in this session. Won't have to worry about a special session or anything, and we'll override the veto. We hope, because there have been a number of discussions before we got to this point where we put in legislation. We had conversations with the governor on numerous occasions. We had a conversation with the governor's attorneys, and fully believe it to be in the governor's powers to have settled this without legislation. You didn't need us. He could have done it, but they chose not to. And that's when we ended up taking the action that we did. So.
Mr. Chancellor, any similarities? Did Louisiana go through anything like this?
Yes, actually, Louisiana had a higher education desegregation case that actually began in the 70s. So, Senator, when you say 14 years, that's a short time. I personally was involved in a school desegregation case that originally was filed in 1956 and was ultimately settled by me and some other attorneys in 2003.
That's all.
So yes, Louisiana, Mississippi, there's a number of cases that were called the Adams cases that were essentially brought by the United States Department of Education. Maryland somehow was not included in those ultimately. So Maryland continued to engage in a number of practices all the way up to 2005 that clearly were even much worse than whatever happened in Tennessee, Mississippi, Louisiana, Alabama, Texas, et cetera, et cetera, et cetera. So I think the critical thing that we want to think about when you think about the Louisiana case, the Mississippi case, because Fordyce is kind of the most recent case that everybody leans on, and particularly in Maryland, to try to figure out how they correlate, is that the state of Maryland never actually had laws. It was more about policy. Okay. Whereas Louisiana and Mississippi, there were actual statutory laws that are still in the books that actually are not enforceable because of the 14th Amendment. So if you ever have a flip in a real way like that was attempted, say, on January 6th, some of those laws would go back into effect like quickly. And at least in Maryland, you did not have that, and you had a chance to create some resolutions that were not really applicable in that particular situation. One of the other things I think was as critical in Maryland is that there has never been a serious attempt, from what I can tell, to actually close down HBCUs in a real way. I mean, other than maybe starving from funding, something like that, but there has actually been legislation in Louisiana to actually merge or close HBCUs. In fact, in 1989, Judge Schwartz, in 1988 or 89, actually, as part of the order in Louisiana, ordered that Southern University Law Center be merged with the LSU Law School. So I tell folks the story that when I came on the faculty in 1990, officially the school was about to be closed. So I should have only had 1 year, and 30 years later, I'm still hanging around. So there you go, the strange world.
Let me just say how appreciative I am of the Chancellor's perspective, because it should remind us. We keep talking about a lawsuit that's 14 years old, but this is only the latest chapter in a decades-long struggle in Maryland that has played out through politics and public policy. It wasn't until this coalition was formed and represented by the Lawyers Committee for Civil Rights Under Law and the law firm of Kirkland and Ellis, who took this case for the coalition pro bono, represented them pro bono, and really litigated to the hilt with the state of Maryland and their private counsel that they retained, that it became articulated by a federal court. But we shouldn't forget that this isn't just a 14-year struggle that we're trying to conclude in a settlement. This is a decades-long struggle that we're trying to finally get some remedial relief. It came as the result of a lawsuit, but ultimately needs legislation and the governor's support to finally see some relief.
And might I add, Professor McConkey, just from a historical standpoint, you talk about the Lawyers Committee for Civil Rights. the name of John Britton has to be part of this historical legacy, because it was John Britton who was the general counsel of the Lawyers Committee for Civil Rights who really took this on. I learned about the case in 2005 when he recruited me to file a lawsuit after Hurricane Katrina called McWaters versus FEMA. And we took on the Bush administration at the height of its popularity. And it was considered political suicide that he says, well, John, I'm about to do something else. And I said, I'm with you, buddy, and actually saw a lot of the background. And for example, when you talk about the high programs, the high level programs, innovative programs, there's some very interesting reports by Dr. Conrad that if you're very interested in seeing what he really developed, he laid out a basis for this in a real way that it should be read because they provide some very interesting insight into the strategies and the demands that were made in the case.
Ms. Thomas, any other questions?
One more question asks, did the state appeal Judge Black's decision?
Professor McConkey?
Yes, the state appealed both the liability ruling of Judge Blake as well as the remedial order of Judge Blake. And on appeal, briefs were submitted to the United States Court of Appeals for the Fourth Circuit. An oral argument was actually held in Richmond, where the Fourth Circuit Court of Appeals sits, in December 2 years ago. Now, the Court of Appeals could issue its opinion at any given moment if it so chooses. It is my assumption that it has not done so because the court is aware of these very formal efforts to resolve the case through legislation. And in fact, the Court of Appeals did issue one memorandum order. About 1 month after the oral argument, the Court of Appeals issued a very unusual memorandum that basically said to both parties, to the state and to the coalition, we still think this case can be settled. And so that gives you an idea of where the Court of Appeals sits right now, but it could issue an opinion at any given moment. But I assume that it is watching carefully to see how this legislation proposed by Senator Sydnor and Delegate Barnes is going to play out ultimately, and see if the case can settle.
Great. All right. So are any, I see we might have another question there or not?
We can do one more.
Okay.
This one asks, are there ways in which HBCUs could possibly find funding elsewhere if this case does not end with a settlement?
This case is going to end with a settlement.
I'll take a little bit of that on, being that I have to do that every day. So here's what's interesting. The federal government, in a strange way, has enhanced the ability of HBCUs to do some things that if the state of Maryland and the legislature is successful, and I think they will be, I agree with you, Senator, it's going to happen. So there are a lot of things that are happening in the arena of Title III funding from the federal, from the Fed, the Partners Act, for example, which a lot of people don't understand yet, but that's another one from the federal level. Money in the stimulus packages, stimulus 1, now stimulus 2, and what I think will be stimulus 3. So there are dollars that will help. Of course, the other pressure that has to be put on, irrespective of the settlement of potentially $577 million, is to make sure prospectively that funding is never actually disparately distributed. In other words, now your eyes are open and you say, hey, there's a disparity in the funding based upon whatever. So I would think the state of Maryland would say, which they are, is that, well, over the last X number of years, we probably have been giving HBCUs a little extra money without saying that that's part of the remedy. From that standpoint, I think part of that solution is say, keep getting the extra. We don't have to ever acknowledge your liability, but the extra is kind of a secret way or a non-public way of saying we recognize that we committed some wrong and we want to, quote unquote, be equitable by giving a little extra to enhance missions. Those are kind of the other ways things are done that are not necessarily discussed in public venues. But Senator, you know better because you're in the corridors there in Annapolis. I won't give away any of your trade secrets.
It is important to add to that significant comment that none of that funding, there are sources of funding to HBIs, just like there are sources of funding to every other university and college in the country that comes through the federal government or other sources. But none of that is money that is used to remedy the constitutional violations for which the state of Maryland has been found liable. The state alone is responsible for that funding, and it must comply. It must remedy it, either through this legislation or by order of the court. In one fashion or another, the state of Maryland is going to have to remedy the violations for which it is liable. And also, it's important to understand this in context that all of this funding from the state, funding from the federal government, impacts other sources of funding for HBIs from the private sector. And that's one of the great legacies of Jim Crow, is that it has left the HBIs at such a disadvantage with respect to foundations and raising money privately that they may never catch up. But it underscores the significance of why the state has to step up now and implement a remedy.
A couple others. I know we had some hands raised, and I know Senator Sydnor is going to have to leave soon also. So, Brianna, how are we doing?
I see two more in the Q&A right now. This one says, did the last federal administration give millions of dollars to HBCUs? And if so, does it affect the pending settlement?
Well, the answer is because of the work of Thurgood Marshall College Fund and United Negro College Fund, there have been significant sources of dollars from the federal perspective, but it has no impact because essentially there's a principle that a state cannot there has to be a maintenance of efforts. The state cannot let the federal government come in and provide funding to its state institutions and all of a sudden abrogate its own responsibility to provide state funding. So for example, in one particular area, which is land grants, 1890 land grants versus 1862, University of Maryland Eastern Shore is an 1890 land grant. And Maryland, like most of the southern and border states where the HBCU land grant institutions have never provided the matching funds in the same way that has been provided to 1862 land grant institutions. In this case, it would be the University of Maryland at College Park versus UMES, which is an 1890 land grant in Princess Anne County.
One more, and then we'll turn it over to Imani.
Last question. Will the HBCUs be required to meet any standards or criteria in order to receive the funding over the 10 years? Or will payments be automatic if the legislation passes?
Senator?
The payments will be automatic. So one of the things that's a little bit different from this year's bill as opposed to last year's legislation is this year's bill has actual floor in it so that none of the 4 schools will receive less than $9 million during that entire term. Last year, legislation, this wasn't the case. In fact, I can remember sitting in chambers when we were about to do third reader in the Senate, and just remember seeing a number of emails coming through my computer from people who were watching this legislation who felt that some of the institutions weren't getting enough money. And I'm sitting there about to pull out my hair because I'm thinking you all are worrying about the distribution of the money and I'm worrying about the actual vote. So I say that to say this year, Coppin is being allocated more money than what it received last year. So I think schools like Bowie and Morgan, they actually are receiving less money under this year's legislation than last year's, but none of the institutions will get less than $9 million.
Well, fortunately, Bowie got some recent support that was not from the
it's interesting that you bring that up because that when the 3 of those 4 HBCUs got this money, this McKinsey money, I can remember this summer reading a quote from one of my colleagues that had me a little concerned that one might compare the money that these institutions were getting from a private funder as a way of diminishing the amount of money that they were supposed to get under this lawsuit. And what I kept telling people was, look, one's about settling the lawsuit, and one's money that these institutions were not expecting to receive, and one shouldn't offset the others, apples and oranges. So
we need both sets of money.
Absolutely.
All right. So, Dr. Miller, I hope you're optimistic about the way things are moving now.
I'm a person of faith. Everything can be done in God's name.
With that, we'll turn it over to Ms. Payne. Thank you very much. Ms. Payne?
Yes, thank you, President. First, I want to thank our distinguished panelists. Thank you, 1, for your time tonight. Thank you, 2, for your perspective. And 3, thank you for continuing not only to fight, but to advocate for HBCUs and the students, their constitutional rights there. Before we all go, I also want to add, as the symposium editor and as an executive board member of BALSA, I'm not just that. I'm also a proud HBCU grad of the illustrious Bowie State University. So from a student's perspective, I experienced from 2012, from 2016, the difference between my school and the University of Maryland, between my school and Towson. Why? Because I had friends there, because I had siblings that went to other schools, and my experience was drastically different. Why? Because of funding. Because of funding. I had great faculty. We have Dr. Miller here, one of my professors. I had also great support. However, without the adequate funding, it's not the same. So the federal judge ruled in HBCU's favor. We have the legislature now that is trying to push forth a remedy. So I implore all of you, as you heard today, to continue to advocate, continue to fight, because just like I graduated from an HBCU in Maryland in 2016, the problem still persists. So with that, once again, I thank you all for joining us. I thank you all for your advocacy, for your support, and for your time. Thank you all.
Well, I too want to join in thanking you. This is vitally important. We hope that the legislature, that the legislation does pass, that it's not vetoed, and even if it is, that it's overridden, because the time has come for us to settle this and then to move along to make our system of higher education even greater for the state. So Chancellor Pierre, and to Professor McConkey, and to Dr. Miller and the Senator Sydnor, we do thank you all very much. And Ms. Payne, are we adjourned at this time?
Yes, sir. Thank you all again.
Thank you.
Thank you very much.
Thank
Good night,
you.
everyone.